Oops.
Good afternoon, everybody, and welcome to the 10th District Court of Appeals with a panel from the 1st District Court of Appeals sitting for the 10th District. We have arguments today on two related appeals in the case of Calypso Asset Management et al. Versus 180 Industrial LLC, case numbers 20 AP 122 and 20 AP 124. This, as I mentioned, it does involve two appeals. I know that the court has been in communication with both counsel about timing issues and procedural issues. So today, each side will have 20 minutes to argue. 180, who filed the first appeal, will go first. Then Calypso Asset Management, CAM, will argue second. And then 180 will have a rebuttal period, and CAM will then have a rebuttal period. So counsel, if you are both ready, as I mentioned, 180 will begin first. Anytime you're set, and if you'd like to reserve any time for rebuttal, let me know and I will keep your time.
I think, Your Honor, what I would like to, this is David Wallace on behalf of 180 Industrial LLC. What I'd like to do is split my time 10 minutes, if that's okay with the court. That's
fine. So whenever you're ready, go ahead and I will keep your time.
Very good. Thank you. May it please the court. Again, my name is David Wallace. I'm here today on behalf of 180 Industrial LLC. This court held in the first appeal that no reasonable attorney should have filed this case in the first place or continued to prosecute it. My client 180 didn't start this case. CAM, Bruner Quinn, and Altera did. All we did was successfully defend the case and vindicate our rights under a purchase agreement, settlement agreement that provided a contractual right to attorney's fees, and under our statutory right to seek sanctions as a person that was aggrieved by frivolous conduct. CAM, Bruner Quinn, and Altera put this case into motion. Yet somehow, in the trial court's decision, 180, the victim here, has been recast as the villain. There's no basis for that. As the prevailing party in this frivolous lawsuit, we're entitled to a fair and reasonable review of our attorney fee petition, and including a proper consideration of all the work that we did to get to where we are today. And that's based on our contractual rights. As the aggrieved party in the frivolous lawsuit, we're also entitled to have the court take a look at what happened here and assess a sanction that's going to punish, as the sanction statute is intended to do, and deter future misconduct.
And the sanctions award here basically was just overlapping with the fee award, so there was no additional award for the sanctions. Am I reading that right? It was a total of $55,000 and not two separate $55,000 awards.
That's the way we read the trial court's judgment, Your Honor. It's one assessment, joint and several against CAM and their attorneys, Bruner Quinn.
Is there any way that the trial court, I mean, I know you're arguing that under the fee shifting provision that the trial court's determination of what fees were reasonable was incorrect, but the court under the sanctions piece of it couldn't have awarded more fees than what the court found to be reasonable, could it? I mean, it would have to be the same amount, right?
I think that argument has been made. I think that the court can fashion a sanction that's appropriate, that results in the appropriate punishment and the appropriate deterrence. I mean, if I think the court, if the attorney's fees were $100, I don't know that the court is capped at that. I think the court can fashion a sanction that is appropriate and punishes appropriately and also deters appropriately.
But doesn't there have to be causation from the sanctioned conduct to the fees? So in other words, the sanctioned conduct generated a certain amount of fees, so you would be capped at those fees, right?
Well, there probably should be a causal connection there. And that's where here what the court did is it tied the assessment of the sanction to the attorney fee that it awarded. and felt that that was an appropriate sanction. Here, since what we're arguing here is that since the trial court tied the sanction to the attorney fee award, and the attorney fee award was atrociously low and wasn't properly calculated under the lodestar, that if the trial court thought that the appropriate sanction here was the attorney's fees that were reasonably incurred in defending the case, then if the trial court did not properly conclude what the amount of reasonable attorney's fees was, then it needs to reconsider the sanction.
Well, let's talk about the calculation, and let's start with the block billing, because I read the Supreme Court's recent decision on that, and it was pretty unequivocal. It said no way, shape, or how are you getting block billed fees from our court, from the Supreme Court. So what are we to do with that decision?
Two things. First of all, the Supreme Court was sitting as a trial court in that case. It was an original jurisdiction case. And so it was sitting kind of like our trial court is here, determining what the appropriate attorney fee award should be. But in that case, it's important to note that in the Rubino case, which is the case I think you're referring to, Judge, the court went ahead and reviewed the attorney fee petition that was in front of it. It reviewed it. It determined specifically that there were circumstances where counsel had done the same, were doing the same work. They had duplicated, they were talking to each other all the time. And if you look at that case, there were like 10 different lawyers from 2 different firms that all talked to each other. And the Supreme Court basically said, that's too much. We're not going to give you all that. We're going to have to cut some of that. And they made percentage reductions to account for that. But the important thing in that case is the court did review the attorney fee petition, and it did make a reasonable assessment. What it pointed out is that it's a lot harder for a trial court to figure out what's reasonable if there's block billing. And we don't do that.
Well, I mean, I've seen plenty of cases that have said, well, we're going to reduce it by 25% or 30% for block billing, and that makes sense to me. But that's not what the Supreme Court said. I mean, they said no block billing. And that's what concerns me about your argument in that.
Well, let me respond to that, Your Honor. That was a prospective decision that the trial court made in that case, or excuse me, the Supreme Court made in that case, which applied to Supreme Court cases. There's nothing in the Supreme Court's decision that would indicate that it was indicating that every trial court across the country had to adhere to what the court had decided in Rubino. That was basically the Supreme Court saying, if you're going to submit a fee petition to us, you better submit it this way or you run the risk. And that's what the court said. The court said you run the risk of not having your attorney fee petition. So I'm not sure I agree with you, Your Honor, that it's a bright line, absolute legal rule that they're not going to consider fee petitions with block billing in the future. But let me make one more point on that aspect. If our trial court had a case management order that said only submit fee petitions, let me put it another way. If our trial court had a standing order that said, if you submit a fee petition with block billing, I'm going to disregard it, we would be on notice of that. If I'd have known that, I would have told my counsel in Utah, don't block bill. But we didn't have any advance warning that that's what was going to happen. And so it's frankly unfair for the trial court to do that to us. The trial court could have told us the first fee hearing when he looked at the fee and told us that was the situation, because some of the fee petition, some of the attorney fee affidavits were the same ones that were in both. He didn't hammer us like that in the first case. He only did it secondly. We should be entitled to some warning that this is going to happen. And that's exactly what the Rubino court and the Supreme Court did. It said, okay, we're going to look at your fee petition here, folks, but in the future, we're not going to consider them.
Well, isn't the warning though the Supreme Court case? And then how can we say that the trial court abused its discretion when it had that guidance and it had that basically the discretion that the Supreme Court gave it to disregard block billing?
The other point that I would make, Your Honor, is that all the cases that the Supreme Court cited did not absolutely ban block billing. They all talked about finding a reasonable amount of a fee. And that's what Ohio courts are supposed to do when they get a fee petition in front of them. They're supposed to determine what a reasonable fee is. And just because the block billing is in there doesn't mean the court cannot accomplish that task. It should only be a situation if the court looks at the block billing and says, I am unable to figure out what a reasonable fee is here because of the block billing makes it impossible. And like I said before, the decision in Rubino did not strike me as a mandate to all courts in Ohio that this is the way petitions shall be determined in the future. Now, it may be if in this case we get up, if this case goes a certain way, whether we appeal, they appeal this, we might get a decision out of the Supreme Court there. But I think that would be the proper way for the Supreme Court of Ohio to make a broad-based rule of the way that the block billing should be treated in Ohio courts. The Supreme Court was talking only about its court and only about its challenges that it was facing in trying to fashion a fair fee petition based on the fee petition in front of it in Rubino.
You have a little more than a minute left if you want to reserve.
Wow.
Can I interject with another question?
Of course.
So let's leave block billing aside. There were certainly significant cuts by the trial court and the other aspects. I think the difficulty is it is abuse of discretion. The court did go through an analysis. It didn't go item by item, but it did go through an analysis of the fee records. And so in your minute or so, I think, like, where would you focus us to find an abuse of discretion from your argument?
Where I would focus you, Your Honor, is a couple things. First, the percentage reductions that the court applied in applying them, the model rule 1.5A factors, essentially duplicated the reasonableness analysis the court should have been doing at the lodestar. Certainly some of the block billings that the court struck may have included some of the types of improper, unreasonable, unnecessary type of work that the court struck again under the rule 1.5A, 1, 3, and 4 factors. So it is an abuse of discretion, Your Honor, if the court reduces an attorney fee more than one time for the same reason. That is an abuse of the court's discretion. It has discretion to take a look at what's reasonable, but it can't deduct twice for the same purpose. And the other thing I would point you to is the fact that the work in the first appeal, which the court struck in its entirety, was simply reused in the second appeal. So the work that was struck there as unnecessary was not unnecessary. It was completely necessary to us winning that portion of the appeal for the second time when it went up on appeal in 180. So very quickly, that would be my response to your question, Your Honor.
Mr. Wallace, you are at your time if you want to reserve 10.
I will reserve the 10 minutes I asked for before, Your Honor, and we'll pick up then. Thank you.
All right. Mr. Quinn, would you like to reserve any of your 20 minutes?
I would, Your Honor. I'd like to reserve 5 minutes, please.
All right. Anytime you're ready.
Okay, very good. Thank you, Your Honors, and may it please the court. Patrick Quinn on behalf of Cam and Altera and my firm. I think it makes some sense to start with this question that we spent a great deal of time on already is the amount of the reasonable fees incurred. Because to your point, Judge Krause and Judge Bergeron, the amount of the reasonable fees, or the amount that the court determines to be the reasonable fees, in fact, is a cap, is a ceiling on anything that can be awarded as a sanction. That's directly in the statute, which is quoted in the briefs. 23-23-51 B3 says a sanctions award, paraphrasing here, it's quoted in the briefs, but to paraphrase, says a sanctions award may be equal to but shall not exceed, or maybe, shall be no greater than the reasonable attorney's fees. So depending on how this court were to resolve the dueling arguments about the amount of the fees, that may moot or dispose of some of the questions on the sanctions.
Mr. Frank, can I ask you a question and jump in? And I'm going to jump in and interrupt on this because it's in my mind. Is it your position that all block billing is improper and should be stricken by the court?
It is certainly my position that it is not an abuse of discretion for the trial court to have done so.
Let me ask you a hypothetical question then. If an attorney were in trial and we knew that the trial day itself from the beginning to end was a 7-hour day, and there was a block bill time for 7.5 hours, and the block bill time said, trial, and then an additional entry that said review correspondence from client. Is it your position that even though everybody knows that that person was in trial for 7 hours, the fact that it's block billed, if the court struck it, it wouldn't be an abuse of discretion?
I think in the context of the hypothetical you've raised, where we have some kind of independent or separate reason to say we can break out that 7.5 into a 7.5 hour block, that maybe presents a different question. Because in that scenario, you've got a judge or a concession by the opposing party or whomever that says, okay, yeah, we know trial was 7 hours. It was, 9 to 5 with a 1 hour break or what have you. We don't have that here. So I would say, I would go back to, what Judge Bergeron has kind of alluded to earlier. Harris is, the Supreme Court decision, Harris is pretty unequivocal in saying we don't, going for, and Harris is a 2018 decision. The trial court here was 2020. Harris is pretty unequivocal in saying we will not allow, going forward, we will not allow these.
But when was the initial fee application? Was that pre-Harris?
The initial fee application, I believe, was, because recall that there was a motion filed. The
right. Well, so my question is back to what Mr. Wallace said about, hey, there should be notice to us about it. Like, what would be wrong with, if the trial court had said, okay, well, we now have this Harris decision, redo your bills to disaggregate the block bill time and write off, obviously, any time that is not germane to what's appropriate.
I think I would respond in two ways. Number one, as Judge Krause alluded to, the Supreme Court's decision puts everybody on notice in and of itself. But more importantly, this court, the 10th District, long before Harris, had already criticized block billing in a case called Hikmet that's cited in our briefs from 2009, I believe. I argued Hikmet as a young lawyer. So the long before this case was ever filed, the 10th District was already on record as disapproving of block billing. And in that case, affirming a disallowance of fees that were reflected in block billing entries. And so the question is, and of course, this has been alluded to, this is a discretionary review. There's certainly nothing, given the longstanding rule in Hikmet and given the ample time in between the Supreme Court and Harris and the hearing that led to this appeal before us now, for 180 to do exactly what you said. Disaggregate your bills, those sorts of things. There's plenty of notice, and there's certainly nothing I would submit that suggests that it's an abuse of discretion, even if the trial court could have gone other ways or might have gone other ways. I don't believe you can say it's an abuse of discretion for it to rule as it did.
What about the argument that in effect there was double reduction, that the trial court reduced certain percentages and it ended up duplicating it?
I don't believe that is borne out by what the trial court, I don't believe that to be a correct argument. What the trial court did, and we can see exactly what he did, because he, fly-specced and hand wrote on 200 some pages worth of invoices, disregarding things as, unnecessary or what have you. Which is an analytically a distinct question of reducing something based on the 1.5 factor, 1.5A factors. Of course, in the prior appeal, this court told the trial court, do what you did. Figure out the hours and the rate, multiply them together for your initial estimate, and then apply Rule 1.5. And that's,
didn't he disallowed $170,000 of attorney fees because he said those were looking for sanctions, right? Those were all, he disallowed those completely.
He noted that to be the case. I don't believe the court said, I'm not awarding you any fees for seeking sanctions. He did note the math, As you said, about 170,000 or so was spent pursuing sanctions, but did not take the step of saying, I'm disallowing 170,000 because you spent it pursuing sanctions.
But then he further reduced the attorney fees, I believe, by 25% because $170,000 was pursuing sanctions, right? So isn't that a double ding?
No, I don't believe it is. I mean, the initial request was for about $250,000, and the trial court went through it. And there's, I think, there are 3 charts in the written decision showing the math of how he gets from A to B. And he starts by disregarding what's, the block billing, disregarding stuff as being deemed unnecessary or vaguely time entered. And that produces what the lodestar analysis calls, quote, the initial estimate.
Well, but let me ask you this.
Yes,
if you start from the overall, whatever the figure was, $230,000, what the award ends up being is like $44,000, which is a substantial cut. When this court has already found that they were the prevailing party, which means they're entitled contractually to fees, and there was sanctionable conduct. So it's like they had to run the gamut of both an improper suit and frivolous conduct to get vindication. And yet the court essentially gave them a quarter or so of what they were seeking, which to me, from a macro perspective, is troubling.
What I would say, Your Honor, is, again, we're talking about a abuse of discretion standard here. The trial court followed the exact, and this is with respect to both the contractual, the amount of contractual fee shifting, as well as under the frivolous conduct sanctions award. The trial court followed the exact analysis and process that this court ordered it to do. Justified and explained why he discounted things at the first step as being unreasonable or unnecessary or vague or reflected in a block billed entry, those types of things. And those are all clearly delineated. Trial court then went through all 8 of the 1.5 A factors and explained why he was further reducing based on those factors. There's obvious disagreement with the decision, with the outcome, but what seems to be lacking from the briefing by 180 is something that shows or anything that indicates that it's an abuse of discretion. I mean, the trial court could properly discount time based on, for example.
What about their initial appeal, where the appeal was dismissed for a lack of a final appeal order? Like, why would, I mean, jurisdiction to me in that case seemed questionable. And as a former appellate attorney who was always concerned about, getting dinged for lack of jurisdiction,
sure,
you always file a notice of appeal if there's even a colorable claim of appellate jurisdiction. So why was that so wrong that they should have gotten nothing for that?
Well, I think the question isn't whether, respectfully, isn't exactly why was it so wrong. It's, did the trial court abuse its discretion in deciding that an appeal, excuse me, in deciding that an appeal or the time spent pursuing an appeal that was dismissed for want of jurisdiction was reasonable or not. The trial court felt no. On appeal before this court now, 180 says, and we heard it alluded to this afternoon, 180 says, well, that time was kind of recycled or reused in the second appeal, this current appeal. And the problem with that is, I guess, twofold. Number one, we have no indication or evidence of that argument ever being presented below. And two, we don't have anything quantifying that. It would be one, and they had ample opportunity. It would be one thing if in the proceedings leading to this appeal, 180 had said, okay, we spent 50 hours on the first appeal, and we're going to recycle that or reuse it. I mean, it doesn't, there's no effort to quantify that in the trial court below or in the record, and it is their burden. So I would suggest, and I agree with your observation that, obviously there's always a concern about jurisdiction being, or with questionable jurisdiction about waiving an appeal or waiving arguments by not appealing. I don't think it's a question of the trial court somehow punishing them or anything along those lines. Rather, it's the trial court exercising his discretion or its discretion in concluding that this time is not something that is that I believe is
And did that
reasonably necessary.
first appeal go all the way through oral argument before the court dismissed it? Or am I misremembering that?
No, I believe, yes, that's correct.
Okay.
That's correct. So I don't disagree that there's, the argument is not that the first appeal was taken somehow in bad faith or that it was, or anything like that. It was a debatable question or a closed question or what have you. But again, I think that focuses on the wrong question or the wrong issue, which is could this trial court here in rendering the decision have decided to disallow that time? And I think the answer has to be yes, because there's a remarkable lack of authority that for the contrary proposition that the court not just erred, but actually abused its discretion in disregarding that.
Were your firm's fees put into evidence as a comparison?
They were not, Your Honor. The only
sought in
evidence.
Discovery.
I beg your pardon?
And not sought in discovery or anything?
There was prior to the last appeal, there were some disputes over discovery. This court, the 10th District, in the prior appeal, affirmed a determination that there should be no discovery in connection with a sanctions proceeding. I will tell you the evidence in the record is that my firm handled this case on a contingency or a contingent fee basis.
But for example, in the record aren't the number of hours that your firm spent.
No, that is not present in the record.
And you've got about a little over a minute left if you want to reserve 5.
What I would just briefly say in my final 1 minute address to the sanctions piece, with all respect to the trial court, it did abuse its discretion in awarding sanctions and awarding the amount of the sanctions. And the reason it did so is because it failed to appreciate, it failed to apprehend or understand that it had discretion to award as a sanction a non-zero sanction but something less than the amount of the reasonable attorney's fees. As I said before, or as I mentioned before, by statute, B3 of the frivolous conduct statute sets the amount of reasonable fees as an absolute cap. You cannot, to take Mr. Wallace's argument or analogy, if the trial court found the reasonable fees were $100, the most he could impose as sanctions is $100. That's what the statute says.
I thought the trial court did recognize that it could award no fees.
The court recognized, talking about a case called Scott, which is talked at some length in the briefing and in the decision. The trial court recognized that Scott allowed for the court to find frivolous conduct but not award sanctions. But then the trial court says it's the next step, and I think this is kind of where it becomes apparent that the court misapprehended, misappreciated the scope of its discretion. Its next step is, well, the 10th District has never reduced. I understand I can go to 0. It seems logical that if I can go to 0, I can go to something, 50% or some non-zero number, but the 10th District has never done that. So I'm not going to, and I don't believe I can. And I don't believe that to be a proper recognition of what the trial court's actual discretion in establishing or in fashioning a sanction is.
You are at your time.
Okay. Thank you, Your Honors.
Mr. Wallace, you have 10 minutes.
Thank you. Let me first respond in this way. Abuse of discretion is not unfettered. In other words, a judge can't do anything, and that seems to be the arguments being made to defend the judge's actions here. We put the standard in our brief, and it has to do with what a conscientious judge acting reasonably, is this what they would do? And have they justified it? Have they explained their sound reasoning process? And that's what's missing here. The judge gave lip service to the lodestar approach and the 1.5A factors, but he didn't tie the percentage reductions to anything. And that makes them an abuse of discretion. And let me point out, we presented an expert at the hearing, and the expert testified that with a few exceptions, there was a several-hour cross-examination, and our expert made a few concessions that a few of the entries was work that maybe was not really necessary or whatever, and the judge called some of those out. But our expert said exactly, with regard to the first appeal, our expert said the same thing that Judge Bergeron referred to, that yeah, it makes sense to file an appeal when finality is in question, because if you don't file the appeal, you've lost the right to challenge. And so there was expert testimony governing all aspects of the fee award that we put in. And so we did present evidence, and we did meet our burden to establish the reasonableness and necessity of the vast majority, if not 98% of the work, whatever the number is, that got carved out.
Let me ask you this. So in the first go round, the judge just says, hey, $30,000 sounds like a good number. And we said, no, you need more substantiation. We now have a 20-some page decision that does have a lot of detail. And if we agreed with you and we're going to remand it to the trial court, what guidance would we give him other than, again, if we were agreeing with you, increase the number such that we don't trigger yet another appeal and this ongoing cycle of appeals over the fee award?
I think the court should remand and tell the judge to review the time entries individually, entry by entry or task by task, and determine, was this work that's described in this entry, was it reasonable? Was it necessary? Was the amount of time spent appropriate for this case? Did it relate to the case? Was it necessary to the case? Does it further the case? That's what the judge should do. Individual entries, because what the judge did is,
but didn't the judge do
too
that
much work in this
by delineating on the exhibits the codes that he was using?
Well, if you look at those if you look at the exhibits, Your Honor, what he did is he put a B next to any entry that had more than one task described in it got a B, and it was described as block billing. We even pointed out one entry in our brief that wasn't block billing at all. It had a descriptive description that the judge, in his apparent interest in finding block billed entries, declared to be block billed when it wasn't. It was simply a very specific description of what was done. But having put that to the side, you know, the judge put B's and put some U's next to work that he found unnecessary. But that only resulted in the drop to about $127,000. It was after that was what was left, that $127,000 worth of work. And that's what the judge applied percentage reductions to. And what he should have done is gone through the work that was remaining and looked at it and said, okay, is this remaining work, not block billed, not relating to the first appeal, was this work reasonable and necessary? Was the work necessitated by the issues that were in the case? Some of that relates to our filing of our motion for sanctions. Some of it relates to our filing of our motion for attorney's fees. Some of it related to attending the 3 hearings in the case. Some of it related to attending the settlement conference. Some of it attended to preparing for the hearings. Some of it related to drafting and filing the briefs that the judge ordered us to draft. And so that's what the judge needs to do. He needs to go through and look at the time entries and look at the work was done and make a declaration. I believe that this was reasonable. I believe that this was necessary, but that's not what the judge did. He found block billed entries and struck them out. He found the first appeal and struck them out. He found a handful of things that he disagreed with and he struck them out. Left was $120,000.
So is he gonna have to articulate at every single entry why, or is that what you're saying? He's gonna have to issue an opinion explaining for every time entry why or why not he's going to allow it or disallow it?
He could go that way if he wanted, or he could just say, I find it all reasonable. It would be only if he finds it unreasonable that he would have to explain why he didn't think it was reasonable. So
Okay.
he needs to have an explanation for what he's doing, as opposed to $214,000 is way too much, 25% reduction. That is an abuse of discretion, because that's not fair. That's not fulfilling his obligation as the trial judge to, number one, effectuate our contractual agreement. We agreed with CAM that if we were a prevailing party, they would pay our attorney's fees. it's only qualified by reasonableness, which is what the judge has to do.
But what's difficult is with those percentage reductions and looking at the case law, it does seem kind of arbitrary. I mean, the judges can go through and just say, yeah, 10% here, 20% here. I mean, it seems like all of that has been upheld as not being abuse of discretion.
Those are all different circumstances, I would respectfully submit, Your Honor. That's a circumstance where judges found there was compensable and non-compensable time. Maybe it was block billed, and they said, well, I think 50% of the time would be allowable and 50% not. It takes a shot at it. But here but that's looking at a specific entry and saying how much of it's reasonable, how much of it isn't, or a specific group of tasks. I mean, the judge could also look at it and say, the hearing on the motion for sanctions, 5 hours. I think that's reasonable. He could say it took 20 hours to prepare for the hearing. I think only 10 hours is appropriate. But he needs to tie it to something specific. He has to have a reason for knocking it out. He doesn't necessarily have to have a reason for leaving it in. But if he's going to take it out, in order for it not to be an abuse of discretion, he needs to explain what he's doing, because that's what a conscientious judge doing what he's
but if he leaves it all in, then we get the appeal from Mr. Quinn saying it was unreasonable, and he's going to fault the trial judge for not doing a detailed analysis of the entries that were left in. So I think that's what we're struggling with is, what kind of burden are we putting on trial judges when they're faced with, a mountain of attorney fee records?
Well, it's the burden that trial judges take on, Your Honor. That they have the obligation to be fair to both sides. And being fair to both sides is looking at the entries and deciding, was it too much? Was it too little? Was it okay? But that's not what the trial court did here. He took large swaths of the reductions. And we haven't even gotten to the fact that under the reasoning that the judge used to use 1.5A3 was the exact same reason he used for 1.5A1. The case wasn't complex. Well, that's exactly what the court said for 1.5A1. He said this case only involved a summary judgment motion and not a lot of discovery. So he used the same basis to reduce it twice. Now, with due respect, I believe that would be an abuse of discretion to reduce twice for the same reasons, even if you approve an arbitrary percentage reduction. And for example,
you have about 2 minutes left.
2 minutes left. Let me just say that the judge understood that the Scott versus Namath case was floating out there, and he reviewed it, and that was one of the things that he sort of did right, was determine that the type of animosity that was present in that Scott versus Namath case wasn't present here and didn't constitute any basis for the judge to go down from the attorney fee award that he decided was the appropriate sanction. So he knew what his discretion was, and he exercised that appropriately. I wanted to conclude by just saying that just repeating a little bit, the judge has the responsibility to arrive at a reasonable award, and he has a responsibility to explain the basis for that decision. And that's what the judge paid lip service to the test, but he didn't tie what he was doing to anything specific. And it resulted in an 80% reduction of the attorney fee request down to $44,000 that basically provided no compensation to us under the prevailing party provision for successfully appealing the case, filing the motion for attorney's fees we were entitled to, filing the motion for sanctions, attending all the hearings, getting the trial judge's incorrect decisions reversed, vindicating our rights in that fashion. And so ultimately an 80% reduction in these circumstances results in an unconscionable award that just shocks the conscience here and constitutes an abuse of discretion. And with that, if there's any further questions, we would respectfully ask that the court reverse the trial court's judgment awarding an unreasonably low amount of attorney's fees, affirm the assessment of sanctions against Cam and Bruner Quinn, but reverse the trial court's amount of sanctions as unreasonably low and based on the erroneous attorney fee calculation, and then affirm the trial court's assessment of sanctions against Bruner Quinn based on the Altera claims, but reverse the trial court's judgment, declining to assess sanctions against Altera, and reverse the trial court's amount of sanctions against Bruner Quinn under the Altera claims for as unreasonably low and based on the improper attorney fee calculation. We haven't really talked about the Altera claims, but we believe the judge incorrectly interpreted and relied on the evidence in finding that Altera did not commit frivolous conduct here. It's an objective standard. The claims had no merit, and therefore Altera is equally responsible for frivolous conduct here.
Mr. Wallace, you are at your time.
Thank you.
Mr. Quinn, actually, I'm going to give you 6 minutes because I give Mr. Wallace an extra minute. So you have 6 minutes left.
Thank
Mr. Quinn,
you, Your Honor.
I'm sorry
Yes,
to butt in, but can you just quickly address the Altera claims and explain what was the tortious interference claim and how was Altera not engaging in frivolous conduct, but then I'm just trying to understand what was going on with the Altera claims.
The Altera claim is, I guess, two points. Number one, obviously, we spent a very minimal amount of time on that subject this morning, which is kind of reflective of the kind of proportion of the case that Altera was involved in throughout. But the tortious interference, the basic theory of the case was that there was a proposed transaction in which Altera was our broker, that would have is a sale leaseback for this particular property. Our basic theory of the facts is that our basic allegations are that 180 essentially tanked that deal, not in good faith, turned around and then attempted to strike a deal that cut us out of the process. Altera would have received, had our deal closed, Altera would have received a commission, and we believe that there was we allege that there was a tortious interference of the prospective advantageous relationship arising out of that proposed sale leaseback. That's never been, wasn't addressed, of course, at all by this court in the prior appeal. The argument seems to be that, well, Cam engaged in frivolous conduct, my firm engaged in frivolous conduct, ergo Altera must have too. And I'll stand on my briefs on that point, but will note that, when this court remanded last time, it did so expressly for the consideration of whether Altera engaged in frivolous conduct. If it was an automatic, then as 180 seems to argue, then it wouldn't have remanded, it would have just simply instructed. So I don't believe that holds water. A couple other points, I'm struck by, as Mr. Wallace describes, what he would have the trial court do is what the trial court already did. The trial court fly-spec the invoices, disregarded things as unnecessary, and then went through a lengthy analysis of the 1.5 factors.
Well, let me ask you this.
Yes,
looking at 1.5A1 and 1.5A4, the court reduces the first one by 30%, the second one by 25%. But as I read both of those, on a case like this, those are really duplicative because it's asking about time and labor involved in maintaining the litigation, the difficulty of the questions involved, and then 4 is results obtained. So
yes,
you're basically cutting it in a third or a quarter for seemingly overlapping reasons there.
Well, I think if we look at the decision, I don't think they're overlapping. A1 is the reduction in A1 is, the case is not that particularly complex, those sorts of kind of traditional things. When we get to A4, what the trial court explains is, look, you spent $44,000, by your own records, by your own expert testimony, 180, you spent or incurred about $44,000, give or take, to actually get summary judgment in this case, to win the case on the merits. Everything after that, and this is where the 170,000 reference comes in. He says everything after that is, pursuing sanctions.
But if your client had paid it at that point in time, it wouldn't have been incurred. If they had paid the legal fees up to that point in time contractually, that they apparently were contractually obligated to pay, then there wouldn't have been any need to pursue the sanctions. So why should that burden fall onto them?
Well, the sanction, I guess a couple of points. The sanctions motion was filed at the same time as the motion for prevailing party contractual fees. So they proceeded in parallel tracks the whole way through. But secondly, back to the issue of A1 and A4, they're not duplicative, because what the judge explained, what the trial court explained, is A1, I'm ordering a reduction because of the lack of complexity and those sorts of things. A4, he said, I'm ordering a reduction not because of the results obtained, but because the amounts at stake were involved. He explains.
Right, but for both of those, I mean, you have to add into the equation the fact that sanctionable conduct was involved, because it's not just an open and shut, summary judgment filing, we take a deposition, we're done. Like, I mean, the court already found sanctionable conduct, and that necessarily increases the fees.
Well, and I don't, this is not, as I think I alluded to, or I answered Judge Krause earlier, this is not the trial court establishing a cutoff and saying, okay, this is when you get summary judgment, you don't get anything after that. That's not what he did. What the trial court did is said, okay, you spent $40-some thousand to win, to get your summary judgment. There's $170,000 sought pursuing sanctions. That's the tail wagging the dog. I'm entering a reduction, or ordering a reduction based on the amounts involved under A4. It is analytically different. I mean, look, a $1 billion case that's resolved in a quick default judgment doesn't warrant $20 million in fees just because it's just because there's a lot at stake, and vice versa.
Well, right, but I mean, the flip side is true too. I've had plenty of cases where the amounts were small, but the attorney's fees were high just because of crazy stuff happening in litigation.
Sure, of course, and if all we had were bare, a one sentence or a one paragraph number, then maybe I would tend to agree, but we don't have that. We have fly spec, 200 pages of fly spec handwritten invoices, or the trial court's handwritten notes on invoices. We have his decision explaining why he decided what he did. And that's the process that Mr. Wallace seems to be advocating for this court to impose, but the trial court already did it. The disagreement here is with the result. And I would, it's been touched on, this is a discretionary, what the trial court decided in that regard is within the scope of his discretion.
Mr. Quinn, you are at your time, but I'll let you finish your answer.
No, I believe I've finished my answer. I was ready to move on to a next point. So I will thank you for your time. Thank you, Your Honor.
Thank you both for your arguments today. We will take the matter under advisement and give you a timely written opinion. That will conclude the 10th District Court of Appeal session for today.
Okay. Thank you.
Thank you.
And judges, if you'll just, I'll send an email to the judges regarding the post-argument conference.